So we've earned your trust and you've decided to retain us at California Divorce Mediators to handle your divorce mediation. What's the next steps? I'm Gerald Maggio, California Divorce Mediator, a licensed divorce attorney, and founder of California Divorce Mediators, where we offer an amicable, lower-cost solution to resolve your case outside of court. In this video, I'm going to explain the California Divorce Mediator process of how we handle your divorce mediation and the steps of your divorce mediation. Number one, retaining. Once you've decided to go with us, we send you retainer paperwork to complete and sign electronically, and that includes a joint retainer agreement signed by you and your spouse. Number two, opening a file. Once we've received the retainer paperwork and method of payment from you and your spouse, the next step is we open up a case and a file through our internet-based case management system, where you will then have 24-hour access to all the documents in your case. Number three, filing for divorce. From the very beginning, we open up a case with the court system that requires us to file a divorce case. One party will need to be the petitioner, the other one will then be the respondent. We work out who's going to be who in that regard. Then we file the initial divorce paperwork and get that back from the court. Number four, serving the petition. Once the filed petition paperwork has been received back from the court, the petition paperwork needs to be served on the other party. Since this is a divorce mediation, we usually handle that by having the other party sign acknowledgement of service by signing a document acknowledging that they've been served. Number five, filing and serving of the response paperwork. This is much like the petition paperwork. We, on behalf of the respondent in the case, file the response paperwork and then handle the service thereof by sending it to the other party, the petitioner. Again, this is generally handled through our case management system. Number six, this step is called the financial disclosures. In a California divorce case and in all mediations that we handle preparing and serving something called a preliminary declaration of disclosure. Each party has to complete one, so we send the parties forms for them to complete with instructions on how to complete that. The parties do so, provide the supporting account documents and statements and paycheck stubs, income and expense declarations with tax returns and so on. It's all part of the process. We handle that on behalf of both parties, prepare it formally for the parties to sign, then we exchange it on behalf of both parties, and we file the proof of service essentially, which is required by law to get done, so that we get that requirement out of the way. And it also helps the mediator know exactly what all the assets of the parties are, the debts of the parties, and what each party earns. Number seven, the mediation sessions themselves. Once we've gotten the initial requirements of the case out of the way, then we set the first of several mediation sessions, which are generally 2 hours in duration, where in those sessions we go through, prioritize the issues, determine what the parties want to discuss first, and then basically go through the list and go from there. After each mediation session, the mediator will generally put together a detailed email for the parties to understand what the parties came up to in terms of an agreement, what pending issues are existing, what homework need to be done by one or both of the parties to get together additional information that might be necessary for the next mediation session. The goal of the mediation sessions is to work towards a marital settlement agreement as part of a final judgment. Though not very common, in some mediations it may be appropriate to work out temporary solutions while the mediation is pending. That can be coming up with temporary agreements regarding child custody, support, what we're doing about community business, and so on. So it may be necessary to draft up something called a stipulation in order, which is just temporary orders to address those issues while the mediation is pending, depending on how complex the case is, how long it may take. If it's likely going to take more than a typical case, it may be important to get those temporary orders in place so that the parties can then focus on the next steps of resolving their case through the mediation. The next major step is drafting up a marital settlement agreement. If after the series of mediation sessions have come to result in the resolution of the pending issues in the divorce case, the mediator will then put together a marital settlement agreement as part of a complete judgment, which spells out in detail what the terms of the parties' agreement are. Once parties have come to a fully agreed upon marital settlement agreement, that they fully understand the terms and they agree to them and don't have any other questions, the next step is getting the marital settlement agreement and judgment filed. The marital settlement agreement is part of a complete judgment, so there is the agreement itself as well as required forms that go with it. Most of the forms can be electronically signed, but the marital settlement agreement needs to be notarized. So we give you instructions on how that happens, what needs to be done, and then we go from there, have you get it notarized, and then all that documentation needs to be returned to us for the next step. The next step after we've gotten a fully executed marital settlement agreement and completely executed judgment is that we submit it on your behalf to the court for filing. Once it's submitted to the court, it can be processed as quickly as a week. It potentially can be take as long as 2 or 3 months to process. What happens when your divorce has been finalized and the judgment paperwork sent back, you as the parties before us will get something back from the court that's filed called a notice of entry of judgment that will state that your divorce was finalized on this date. It's a one-page document. You'll know before we do that your divorce has been finalized. Then we afterwards get the rest of the paperwork, including the marital settlement agreement, as part of the rest of the judgment back. Once we get that, we send that to you, so you have a complete copy of the paperwork, and that means your divorce at that point is finalized, except there may be some extra issues which I will describe in a moment. Final steps. In your divorce case, we may have worked out that you need to divide up your retirement accounts, for example, by something called a quadro, Qualified Domestic Relations Order. If that's the case, we then take the next step to get things set up so that you can get a Qualified Domestic Relations Order, or quadro, done so that the retirement accounts can be appropriately divided. But that's usually done once the divorce judgment has been filed, and we help you with getting that next step going. There also may be other issues, including a sale of the marital home or a buyout of one of the parties' interests in the marital home, or a division of other assets that need to then be finalized once the divorce judgment has been entered. We usually stay on the case to make sure that there's no questions or issues regarding that. But that's usually the remaining issues that might have to be dealt with once your divorce has been finalized. If all other issues have been resolved and your assets have been divided, including retirement accounts, essentially we're done with your mediation. You're done with your divorce case, and you can know that you resolved your case amicably out of court at a fraction of the cost of a traditional divorce, and you can be proud of yourself for doing so. One final point I would make is once your divorce has been finalized, that is the time that you may want to consider getting an estate plan for yourself. Because once you're divorced, you're not going to have a joint estate plan like a living trust anymore. You're going to want to consider getting your own estate plan for your own benefit, for your family, for your kids. Same on both parties. So that would be something I would recommend next. If you and your spouse are looking for an amicable, lower cost way to resolve your case outside of court at a fraction of the cost of a traditional divorce case, feel free to contact us at California Divorce Mediators for more helpful information about the next steps. Come work with us at California Divorce Mediators, where we can resolve your family law issues amicably using our proven mediation process. I'm Gerald Maggio, California Divorce Mediator. If you like this video, feel free to subscribe to our YouTube channel at the end of this video for more helpful information about divorce and mediation issues. See you next time.